plan um, for this particular presentation. So we are going to look at an overview. We are going to have an overview on the new green card rules, like I said, with a focus on those rules affecting current green card holders. Then we are going to look at what we refer to as the gray area under the new rules. Gray area meaning those things that are not very clear, those things for which we cannot say with certainty what the outcome might be if somebody has issues related to what we refer to as the gray area. So they are unclear legal issues actually. Then we'll talk about the transition rules and the implications for extensions. We'll talk about the new rules and the implications for work requirements in relation to different types of extension applications, for example, and applications for permanent residence. We'll talk about the new rules and the implications for applications for dependents. Then we'll also talk about the implications of the new rules for permanent residents, of course. And then we have what we refer to as the do's and the don'ts for green card holders. And then we'll try to outline some of the advantages of being a green card holder. And then we'll talk about what you can do when you think you are affected by an immigration issue, especially in relation to the green card area. Then we'll talk about something we refer to as the red card. In a nutshell, the new green card rules under the Danish Aliens Act, came into force from the 1st of January 2015. So we are not going to focus on those issues related to new applicants, but then we'll focus on those issues related to current green card holders. And in this area, we have two categories of green card holders. We have those green card holders who got a decision on the green card before the coming into force of the new rules. And we have those who got the residence permit based on the green card scheme subsequent to the coming into force of the new green card rules. So if you had a decision from anytime from the 1st of January 2015, then you fall under the new rules. If you had the green card before 2015, then you fall under the old rules. If you get an extension to your green card application anytime after the 1st of January 2015, then you move to fall. If you have a decision to an application for extension from the 1st of January 2015 onwards, then you would find yourself under the new rules. Then one other thing is that before people got rejections to their green card applications and were expelled from Denmark, then you could apply to return to Denmark again under the same green card scheme, because there was no prohibition for you to reapply. But under the new rules, you can only do that after 5 years. And we believe it goes the same for spouses, because according to the law, anybody who got a green card related residence permit can only apply again under the green card 5 years from the last time he got the green card. Then many of these clauses under the new green card rules apply retroactively. That is, some of the rules affect people backwards in the sense that the rules are applicable to people who had the green card before the rules came into force. So the green card applies many of the rules many of the provisions under the new rules act retroactively. And the retroactive effect of the rules start from the date of the implementation of the coming into force of the rules, which is the 1st of January 2015. And if you fall under the new rules, then you know the requirements for extension are different, because then you will need to earn something more, and currently you need to earn over 390, close to 320,000 for the year leading to the date you made the application for extension. So we'll get into details, and it's different from the requirements to work for 10 hours a week under the old rule. So we'll get into those details. Then, in relation to family reunification or application for dependents, the rules have become stricter, and according to the information on the immigration website, it is said that the principal green card holder needs to show that they have financial means for up to 130,000 and 188 crowns, and then the dependent's spouse should also have a similar, the principal should also have a similar amount of money if he's making an application for a dependent spouse. And for each child, then the financial statement or the financial proof should be up to 42,804 kronas. That is based on the current index. And according to the law, these financial requirements need to be based on contract that is valid, a permanent job contract that is valid for at least 1 year, and the principal must have received a salary for 1 month prior to making the application for dependents. So this is something also that is a gray area, because on the immigration website you have information indicating that you can either have a bank statement as proof of financial means to sustain yourself or your dependents, or as the case may be, but then the decisions we are getting from the immigration are like insisting on the permanent work contract requirement. So this is a gray area, and we are working on it. And if you have such an issue, then you can contact us, because we are in the process of getting clarifications from the immigration why we have the requirement for financial for a bank statement in place of work contract still available on the official immigration website. So these are things we can try to fight against, and then we'll get a final solution when we get a decision from the appeal board. Now, when you make an application, you get 2 years work permit, and then after 2 years you need to apply for an extension. Now I'll want to talk about what we consider as the gray area under the new green card rules. When you have the green card and you have lived continuously in Denmark for the last 5 years, and you meet the requirements for permanent residence, which is another issue which we'll have in a subsequent presentation, then you have the right to apply for permanent residence in Denmark. This has implications for those who are green card holders, because when you're making the application for permanent residence, you have to make an application for an extension to your green card. Even if you, at the time of the application, you have a long period of residence permit under the green card scheme. Say, for example, you already have 4 years extension. If you want to apply for the permanent resident, you still have to apply for an extension to your green card, coupled with the application for the permanent residence. So this is what makes it complex. Do we consider the application for the extension to your green card based on the fact that you did it because you're applying for the permanent residence to be an extension under the transition period that we have under the new rules? So I'll just want to explain what the transition period is. Under the new rules, those who got the green card before the 1st of January 2015 have one chance to apply for extensions to their residence permit based on the old rules. And according to the old rules, you need to prove that you have been working for at least 10 hours a week for the 12 months leading to your application. Then I'll need to clarify this. 10 hours a week should not be calculated as 40 hours a month. It should be calculated as at least 44 hours a month, because if you do your mathematics and you do the calculation by the 52 weeks you have in a year, you realize that you need to work 44 hours a month to somehow demonstrate that you've been working for at least 10 hours a week. This is because in Denmark, they give monthly salaries and not weekly salaries. So it's difficult to prove the amount of work you do within a week. So in most cases, the calculation is done based on the work done within a month. So make sure, if you're having an application for extension based on the old rules, you are working for at least 44 hours a month, or you have been working for at least 44 hours a month prior to when you're making your application for extension. And you need to maintain this space of 10 hours a week, or let's say 44 hours a month, until you get a decision. This is one of the most problematic areas under the green card scheme, because the interpretation of this rule is very strict. If the immigration can discover that you were not working for a particular week, then you get a rejection to your extension application. So if within the extension year, what I mean by extension year is the date 1 year from the date when you make your application for extension, and if within this period the immigration can discover that you have not been working for even 1 week, then you will get a rejection to your application. So it's easy for them to discover that you've not been working somehow if you travel to your home country, if you are not an EU citizen, or you travel out of the Schengen area. Then you get a stamp on your visa when you're leaving, and you get a return stamp. So when you apply for extension, you need to give copies of your passport. And then it will be easy for them to see that during your extension period, you had been out of Denmark for over a week. That is sufficient for you to get a rejection to your extension application. So in Denmark, it's acceptable to have 5 weeks holiday.